Hello, I'm Neil Hamilton, a law professor at Drake University in Des Moines, Iowa, and the director of the Agricultural Law Center. I want to welcome you to another installment in our series, Law for Landowners, 10 Things You Should Know. Today our subject is drainage law. The first point to remember is that drainage is basically a natural issue, and it involves rainfall and gravity. There are three basic concepts to keep in mind: the idea of a dominant estate, property that's uphill; servient estate, property that's downhill; and the idea of natural flow, the path that water will seek. A second point to consider is that Iowa law establishes a number of basic rules of drainage. The first is that the dominant estate has the right to drain water onto the servient estate. The second one is that a servient estate has the duty to accept the water that flows off the dominant estate. These principles mean that a servient estate can't block the water back onto the dominant estate, but at the same time, the dominant estate can't collect all of the water on the property and introduce it onto a servient estate in a way or in a manner that causes damages to the downhill property. So the third point to recognize is that over the years, the Iowa courts have dealt with dozens and dozens of cases involving drainage disputes, and through their resolution of those disputes have established a series of principles of drainage law. We've talked about the first two: the right of the dominant estate to drain property, the duty of the servient estate to accept drainage. The fourth point to consider is that most drainage is going to happen based on the natural flow, in that water is going to find a natural water course, and in fact may flow in what we would consider to be creeks or streams or natural water courses. But at the same time, we can make artificial water courses such as ditches, which collect water and maybe dump it or enter it into a natural water course. A fifth principle of Iowa drainage law is that neighboring owners can in fact enter into agreements allocating the drainage between them and deciding who's going to maintain or be responsible for different types of drainage structures. Those types of agreements, or even those type of activities, if they've happened over a long period of time, can establish an easement that allows that drainage to continue, even when there may be new owners of the property. The sixth principle of Iowa drainage law is that if there is a dispute, the person who brings the action has the responsibility to establish, to prove that the Iowa drainage law has been violated. So if you're the dominant estate and your claim is that the person downhill is blocking the water, you have the responsibility to show that. If you're a servient estate and your claim is that you're somehow being damaged by the activities of a person uphill, you're going to carry the burden of proof of being able to establish that somehow what happened didn't meet the principles of Iowa drainage law. A seventh point to remember about drainage law in Iowa is that the law allows for the creation of drainage districts, and in parts of the state that are flatter, where natural drainage isn't sufficient, many drainage districts have been created to establish drainage ditches and other forms of artificial drainage so that the land can be put to productive use. An eighth point to consider is that if you own land that's located within a drainage district, you're subject to the powers of the drainage district to be able to establish and maintain the drainage. This may include the responsibility on your part to pay for those costs, which can be assessed against your property. The drainage district is really a form of a special purpose local government that's been given a series of fairly broad powers under the Iowa law. Ninth, a very common form of drainage in Iowa is the installation of drainage tile underground, which are designed to collect water and deliver it to a ditch or to a natural water course. In Iowa, tiling is an unregulated activity, and Iowa law protects the rights of landowners to in fact tile and drain their property. The right to tile that's included in Iowa law includes the right to put tile onto a neighbor's property so that you can connect to an existing drainage system or to find a natural outlet. A 10th and final point to consider about drainage law in Iowa is that landowners can enter into written agreements allocating the drainage responsibility, and those agreements can be filed with the county recorder. And any type of drainage agreement or tiling record that has been filed becomes part of the title to the property and is binding on future owners of the adjacent properties. Well, that's a review of some of the basic issues about drainage law in Iowa. It's a complicated subject, and as you may know, it's been in the news recently. But understanding these basic principles will help you recognize what your rights and responsibilities are as an Iowa landowner.